Okay, good morning everyone. We're going to go ahead and begin the webinar. I'd like to welcome everyone to the first of a series of 3 webinar broadcasts that Capital Rock Investments will be hosting to cover some pertinent topics in the areas of trust and estates as it relates to the topic of overall financial planning. And today with me in the studio here, we are fortunate to have with us today our guest who I will be interviewing, Bob Kleineck, founder of law firm Oakstone Law. I hope everyone had a chance to read through Bob's biography that was sent out in the invitation email. But for those that may have missed that the short version is that Bob has spent his career working in the area of trusts and estates and spent several years as in-house counsel for a Fortune 400 family office. Bob recently opened his firm, Oakstone Law, and brings strategies and nuances he used for one of the wealthiest families in the country to anyone who seeks his help. So today's format, as I mentioned, will be a discussion interview format with myself, Brad Campbell, one of the founding partners and portfolio managers at Capital Rock Investments, and I'll be interviewing Bob in a discussion type format, and then we'll try to open it up for some questions. I believe on the GoToWebinar meeting system, which this is the first time we're using this technology, there's a place where you can log in and type in some questions that Bob can address at the end of the interview, or you can always contact us at Capital Rock or Bob directly for particular questions to your personal situation. So I think with that we'll get started. The topic that we're going to address today is kind of an interesting one, and we gave it a sort of an attention-grabbing title. It was kind of tongue-in-cheek, so I hope it didn't offend anybody, but the topic is, do you hate your trust now? And I think as we get into the discussion, it'll be more obvious why we use that. And that may be a bit of a strong term, but we at least wanted to get the point across that there are options out there to change or amend existing trusts and ways to build in flexibility for newly created trusts. Okay, so to get things rolling here, I think we'll start out with a discussion on potential problems with the underlying terms that are written into trusts. So Bob, let's start out with this question. What are some of the common complaints or issues that arise with trust documents that you've seen in your experience?
Well, Brad, I think most of the problems or complaints arise from a lack of flexibility within, whether it's within the document or just the overall plan. And some of the questions you can see on the screen here, we frequently see from clients are, aren't the grandkids too young to get XYZ distribution? What if everything's changed now? So an example that we see quite a bit is a trust perhaps is set up to distribute, say, a quarter of the trust principal to a grandchild, for example, at age 25, and then maybe it's a third at age 30 and a half at 35. You've seen a number of these structures, and then age 25 or 30 rolls around, and suddenly the grandchild or grandfather is looking at this and saying, well, maybe that's a little bit too early to be distributing a quarter of this trust out.
Sure.
Is there anything we can do about that? And the answer is, sure there is, and the larger point here is that sometimes in planning, what seems like a very well-reasoned trust structure can, in actuality, turn out to be a little bit arbitrary because these ages are chosen based on the concept that an individual is maturing over time. Maybe they get a bite at the apple and another bite at the apple, see what they do with it sort of thing. But the reality is you really can't tell where an individual is going to be at, say, 25 or 30. So
Absolutely.
Having some flexibility as opposed to having to force those assets out at a time when the beneficiary may actually be in trouble going through a divorce or something like that. So another thing that we talk about quite a bit with clients is trust situs, and this comes up often in the context of state income tax. So the question here is, I've moved to Florida from Ohio, New York, Massachusetts, Illinois, does my trust need to stay in that northern state, or can I move it to Florida with me? And a lot of clients have set up trusts in these northern states that have a state income tax, and the trust may be, in fact, paying state income tax. So one of the things that we frequently try to address is there a way to get around that state income taxing regime? So flexibility can definitely help there. And then finally, one of the big questions always is, what do you mean I have to tell the kids and grandkids about what's in this trust? I have to give accountings and share account statements. And the reality is that the law of really every state at this point requires a certain amount of accountability. In fact, every trustee has a fiduciary duty to account and inform.
And that's a duty to anybody that has a beneficial interest in the trust.
That's right. There's certainly a list of what's known as qualified beneficiaries or current beneficiaries. So it's not every conceivable beneficiary, but you know usually who the players are. You set up a trust for the kids and their kids. So those beneficiaries are usually the individuals that the trustee is required to account to. So,
and this accounting would include the value of assets in the trust, as well as the income or returns being generated in the trust, what it's invested in, all the details, basically.
Exactly, and frequently the most common form of accounting is simply passing on the asset account statements to the beneficiaries. That's certainly the easiest way to account. But to answer your question, an accounting is an annual animal, and there's a starting balance at the beginning of the year. There are gains and losses. There are distributions made, expenses paid, and then there's a final balance, and that's it. That's the accounting in its truest sense. And for many years, often we find that clients are simply not giving accounting to the beneficiaries, and that conversation is always an interesting one, and many times clients are unaware that they're required to do so. So if the trust lacks flexibility in that regard, that can often be a surprise to clients. So that's it.
So Bob, it sounds like a lot of these issues that we've talked about so far in dealing with some of the terms related to the trust documents, and we're talking about flexibility and things like that. Whenever we talk about flexibility, it makes me think that, are we talking about just irrevocable trusts here in this case? And if so, why would somebody or a family establish an irrevocable trust versus a more flexible revocable trust?
Well, good question. Even revocable trusts become irrevocable eventually, and usually that occurs at the death of the grantor. But an irrevocable trust is usually set up during the grantor's lifetime to achieve some sort of gift or estate planning objective. Maybe it's to transfer wealth using a discounted structure such as a family limited partnership. Maybe there's a sale of that asset, an installment sale that the trust is in fact the purchaser of. And also, frequently in the past, life insurance is involved. A policy is set up to hold a life insurance policy. A trust is set up to hold a life insurance policy. So those are some of the what we call inter vivos, or during lifetime irrevocable trusts. But then there's also the idea of doing your more traditional estate planning with a will and a revocable trust. And the revocable trust, as I mentioned, will eventually become irrevocable. So these are the kinds of things that you need to be thinking about, even with a more typical will and revocable trust type planning. So
that's a great point. So I think up until this point, we've discussed a lot of common and potential issues with trusts. So let's move on to some potential solutions for these problems that deal with the terms in the trust, understanding that everybody's situation and every trust situation may be a little bit unique in some regard, but can you kind of walk us through some of the potential solutions to these issues that we've brought up so far?
Sure. Well, just in a general sense, a potential solution usually involves the flexibility that we've been talking about. So what you're looking for is ways to achieve that flexibility and tools to see what kind of tools you have in your tool belt. So the first place we usually look when a client brings one of these issues to us is that, well, let's just take a look at the trust itself. Perhaps it's a trust that was drafted several years ago, in some cases a generation ago. So we take a look at the trust and we try to determine what powers or tools are already built into the trust, and you can see some of them here. A power of appointment is a great example. Sometimes a trust will give the beneficiary a power of appointment, which is a power to alter the ultimate disposition of the property at his or her death. So, for example, I create a trust, I fund it with assets, and I give my daughter a power of appointment, which essentially means at her death, through her will, she can decide at that time the shares to which her children will be entitled. So, for example, let's say one of my daughter's children starts the next Google, and the other is an elementary school teacher. Both noble professions, but perhaps one doesn't need quite as much of a share as the other. So that power of appointment gives another second good look at the issue at a time much further down the road, and that, my child will frankly be better suited to determine what's needed at that time rather than me trying to prognosticate right now. So another power that we look for, I should mention, sometimes those powers of appointment are called powers of disappointment, because if my grandchild irritates my daughter, the grandchild share could be significantly reduced. So,
sure, because you've essentially left that decision-making authority in the hands of the next generation, which is your child, and they're at sort of the behest of your grandchild is now at the behest of your child.
Right, very much so, which is very empowering for the child in the sense of having some say as to how his or her children will access the wealth. Another thing to point out here is this is highly customizable. So I could give my daughter the power to appoint, but only to a certain extent. Maybe I want at least some baseline amount to go equally to the children, but I'll give her some flexibility on top of that. Maybe a power to appoint to charity, for example. Moving on, another power we look for is the trustee's power to change situs or move the trust from, say, Illinois to Florida, which should make available some more friendly state law
and that's a good point. We've discussed situs a couple of times, and you and I are in the business, so that's common language. Just to clarify, whatever state the trust has been drafted in, and for lack of a better term, registered in, the laws of that state govern the parameters of that trust, correct?
Right. There's two concepts. There's the governing law, which says this is how the trust will be interpreted, the state law that controls, and then there's sort of the place of administration, which is more of a technical aspect of things like accountings, for example, which state's law will control.
Right.
So, very good point.
So we're talking about moving the trust situs there, and some of our listeners may be thinking, well, we've been down some of these possible solution roads before, but we're sort of thinking, well, what if my trust doesn't allow any of these changes or modifications? What can we do at that point?
Okay. Excuse me. A couple of those other, if you want to just back up for a sec, Brad.
Sure.
Sorry. The last two powers that we're looking for in the document, this is a great segue to because frequently these powers are not in older trusts. So this power to decant, which gives the trustee the ability to create a new trust and then simply then pour the assets over from the old trust to the new trust, and the new trust can contain more flexible or more favorable terms. And then this concept of designated representatives this is an individual that is designated in the trust document to receive those accountings. So if you've got a number of, let's say, very young beneficiaries that may or may not be able to either A, understand, or B, be ready for all that financial data, you can actually name a trusted individual to receive those on the trustee's behalf, which protects the trustee because the trustee is now fulfilling his or her fiduciary duties to account and inform, but the designated representative is receiving that information. So these are sometimes called quiet trusts. So a lot of times the problem is, okay, well, we've looked at the terms of the trust, but we don't have any of these great tools. So that's the next question. What if my trust doesn't allow these? So that's when we start looking at state law. So, for example, in Florida, there's a statutory right, or not right, but a statutory power to decant, and the statute really spells out in detail the mechanics of that process. There's a notice process where beneficiaries can have an opportunity to review what's going on for the most part. And then another example is side exchange. Florida law permits a trustee, if the trustee follows a few mechanics, to actually move the location of the trust. And then we have other things called trust modifications, and there's a very specific Florida statute dealing with non-judicial or a no-court trust modifications. And in its simplest form, the grantor, the trustee, the beneficiaries all get together in a single document and say, this is a good idea to make this change, and we all agree. And then there's sort of the last resort, which would be a judicial trust modification. That's another Florida statute, and of course this would involve going to court. So that's something that could always be a last resort, as I mentioned.
I see. Okay. Now, it seems like Florida is a fairly flexible, liberal state in terms of governing laws over trusts and estates. What are some of the other states that you think have great flexibility in terms of trust situs and so forth, much like Florida, maybe even better than Florida?
Well, this is an evolving area of the law, and there are a number of states that are actually actively addressing their trust statutes in an effort to draw this business to the state. South Dakota is a great example. South Dakota amends its trust code about every year, always adding the latest bells and whistles, and they've developed a nice little trust business up there, and a lot of very, very wealthy families have located their trusts in South Dakota. Other examples, of course, are Nevada, New Hampshire, Delaware, and even Alaska's gotten into the game over the last several years, which might seem exotic or extreme, but the reality is, in order to establish a trust in one of these jurisdictions, you really need a trustee in that jurisdiction, and there are dozens of ways to bring a co-trustee in from another jurisdiction. So
to satisfy those requirements.
Exactly.
To establish
the situs, exactly. So,
very interesting.
But Florida is doing a great job on its own, not quite as flexible as, say, South Dakota or Alaska, but certainly more practical for many of our clients. So.
Okay. So I think so far, we've focused on problems and solutions related to the written terms of the trust inside the particular trust document. And I think some of those problems and solutions can be related to existing trusts, older trusts, but also as good direction and guidance in terms of developing a new trust, and so forth. But I think let's see if we can shift the conversation into the potential problems with the items or assets that are actually owned by or held in the trust. And that's really the essential purpose of the trust, is to hold some type of asset for the benefit of the ultimate beneficiaries. So we'll kind of transition into that type of discussion. So, Bob, what types of assets do you commonly see held in trusts? I know it can get a little bit exotic and a little bit complicated sometimes. And what are common problems that you see with assets in trusts and so forth?
Okay. Just wanted to, before we do that, just touch. I hate to go backwards, sorry, but I forgot to mention, in dealing with trust situs, you might find that the trust, let's say your trust was established in a state that doesn't have all these flexible powers that Florida or some of these other states we mentioned have. And I just wanted to mention that that's not necessarily the end of the analysis. Another sort of workaround here is we could change the situs to Florida, and then you have the opportunity to take advantage of some of those more flexible,
of course,
trust powers. But getting back into the discussion of what's actually in the trust, certainly you could have a fairly straightforward managed account within the trust, and that's very, very common, of course. But some of the so-called trouble assets we run into, the number one, it probably is the failing life insurance policy. Maybe this irrevocable life insurance trust, which is frequently called an ILIT, for better or for worse. It was perhaps set up 5, 10, 15 years ago, sure, even, and maybe the projections didn't pan out quite right, and then the client is coming to us with a letter saying, "What do you mean I have to put $100,000 into this policy by January, or it will fail?" So that's a big one. And another one is the sort of advanced or sophisticated estate planning vehicles. Even about 10 years ago, the estate tax exemption was $2 million. And now, of course, it's well over 5. So many families set up things like family limited partnerships and either gave pieces of it or sold the entity to an irrevocable trust. And now either that the numbers just don't work out, or it just doesn't make sense, or maybe it's just too complicated. So that's an issue we see. And then finally, it's not necessarily a specific problem with a specific asset, but the question that frequently arises is, how much risk is too much risk for a trustee? And a common, I'll say, misperception is that trust investments need to be invested extremely conservatively, and that's just not really the case anymore, and that's just kind of left over from some really ancient case law. So I know that's something that's important to you, Brad.
Yeah, you and I have discussed this at length. That it goes way back, where in many states there was a list of assets you could invest in, and there was a list of assets you could not invest in, and they've even changed some of the language in there from, I believe it was the prudent man rule, to the now prudent investor rule, which is much more liberal and it's much more reasonable, makes a lot more common sense, for sure. I think also to add a little bit of color to the discussion on the possible failing life insurance policy and the irrevocable life insurance trust, just to provide a little bit of context there. This was a very common strategy under old estate tax exemptions, when the estate exemption was far lower than it is today. And so people faced, giving up more than half of their estate upon the death of the second spouse to die. Right. Because, of course, assets can pass on an unlimited basis through the unlimited marital deduction from spouse to spouse, but then taxed at the death of the second spouse after they've had even more time to grow, potentially. And so that terrified people, and I think people in our industry probably took advantage of that fear a little bit to put some some plans into place that seemed rather permanent, that may just not be a good fit today, or the original purpose of it is it just doesn't, it's not a problem anymore. And how that was done is that annual gifting was used to fund these policies, so that the dollars going into the trust were not considered taxable gifts. Right. And to make them completed gifts, they issued something called crummy withdrawal powers that gave the beneficiaries a limited period of time to withdraw those amounts that were deposited into the trust to pay the premiums on policy, so that it constituted a completed gift. So that was sort of the strategy, and so you were providing the insurance death benefit would pay the estate taxes, thereby leaving 100% of the estate to the beneficiaries, and that was kind of the strategy. I know I've seen in my practice policies that were set up pre-1982, pre-1986 tax law, where there was no limit on the amount of cash you could put into a life insurance contract. And so in some cases the cash values are greater than the death benefits, or at the very least the cash values are approaching the actual death benefit, leaving very little leverage to the strategy. And also, because it's in an irrevocable trust, the perception is that those cash values cannot be accessed by the grantors who may still be living and may need those funds. I've dealt with several situations like that recently. So that's just to give a little more color to the life insurance trust discussion. Can you discuss a little bit for us this fiduciary duty that a trustee has and how that relates to the risk of loss in the assets held in the trust and so forth?
Sure. And you probably guessed by now we've talked about a few fiduciary duties already. There are really a half a dozen core duties, but one of them is the duty of prudence, which again ties back to that sort of almost ancient notion of prudent man. And then there's the duty of impartiality. And really what these two duties are, prudence is pretty straightforward. Your job as a trustee is not necessarily to invest trust assets as you would invest your own, but to invest them as if they were someone else's, which of course is the case. So that's a key distinction, and that's where a lot of the concern comes in, that these need to be ultra-conservative investments. And then the other duty that I mentioned is the duty of impartiality, which is when you look at a trust, it typically has a current beneficiary and a future beneficiary, sometimes called a remainder person.
Sure.
And the current beneficiary may be entitled to, let's say, current income from the trust investments. And frequently, older trusts were drafted this way. We're trying to be a little more flexible these days, and then the remainder person may or may not be entitled to anything currently. So the current beneficiary clearly wants income, and sometimes tax-exempt income. They would prefer that. And of course, the remainder persons want capital growth. They want that pot to be larger.
I'm assuming this creates a bit of tension between the beneficiaries.
Absolutely. There is a bit of tension there, and the tension manifests itself not only in pressure on the trustee by one group or the other, but also in as far as just making distributions and whether mom's spending too much. And particularly in second and third marriage scenarios is where this really rears its head.
I can imagine.
But then, of course, there's also pressure on the trustee on the investment side. Are you investing for growth? Are you growing the assets enough versus, providing enough income for the spouse in many cases? So
that seems to be a linchpin with the asset management side of the trust, is that you really sort of have to have both current beneficiaries and remainder beneficiaries and income beneficiaries in mind as you're setting up a portfolio or whatever the asset structure is inside the trust, because you've got to satisfy both concerns, it seems like, to
right,
fulfill your fiduciary duty.
That is the duty of impartiality in a nutshell. You can't favor one group over another.
I see. I see. Interesting. Very interesting. Let's see what I wanted to ask you next here. I think a good example of this, you and I talked about yesterday, an example that you gave me that dealt with the Eastman Kodak Trust that I thought was a very interesting example, and I think it demonstrates what you described to me as a duty to be reasonable. And I felt a little bit of solace in the fact that there was some reasonableness in the thought process exercised around these trust instruments. Can you discuss that case for our listeners a little bit?
Sure. I don't know if I have every fact at my fingertip, but it's kind of a first-year law school case where it's really unfortunate for the trustees. But the Eastman case, of course, dealt with Kodak stock, and the grantor or creator of the trust, I'm not going to get this verbatim, but essentially the instructions to the trustee in the trust were, thou shalt never sell the Kodak. And, of course, in the 70s and further on, Kodak,
there was no reason to sell. Yeah.
Right. And then eventually Kodak took a nosedive, and the beneficiaries are screaming at the trustee to sell, essentially, and the trustee is saying, I can't, my hands are tied. And this is not, Uncle Bill, the trustee. This was one of the larger financial institutions.
Corporate trustee.
Corporate trustee, right, and really felt their hands were tied. They brought in their legal team, they analyzed it, is there a way to change this?
They were probably afraid of fiduciary liability.
Either way, they were really kind of over a barrel because the assets of the trust are dropping rapidly, yet they felt like selling was a direct contradiction
to the written trust.
So they asked the court to intervene, and the court ultimately decided that the instructions in the trust were asking the trustee to breach one of its core duties, and the trust instructions were effectively unreasonable, and ultimately the sale of Kodak was allowed to happen, or in fact forced to happen. And there were a couple different cases along the same track, but that was the gist of the Kodak case.
Yeah, that was an interesting case that you and I went over yesterday. Some possible solutions to some of these issues we've raised with the assets that are held in the trust. For example, we talked about issues in an irrevocable life insurance trust. I think typically what we would do there is do what we call a policy audit, which is essentially demanding an in-force illustration from the insurance company to see where the policy is today at current funding levels and what future funding levels are required and what that looks like and so forth. And if that's not something that's amenable to the trustee or the trust beneficiaries, there are things you can do. You can attempt to get into a different, more beneficial contract that provides more leverage. Different things you can do depending upon how the trust is worded and what's provided in that trust, and that's where that flexibility is really important. What are the options to a trustee to delegate that fiduciary duty for asset management to a professional? And how does that work? Does that completely eliminate that fiduciary duty that the trustee would have? Say it's an inexperienced trustee from a financial standpoint. What does that look like?
That's a great question. I just wanted to tack on to your insurance policy audit idea that the in-force illustrations are actually a requirement for the carrier to provide upon request. So, and I know you've done that a number of times.
Absolutely.
This is not something that's up to the carrier whether or not they like to charge a fee for it. Right. So that's a great point, and it really doesn't, in my experience, cost a whole lot to have that policy.
Not at all.
Really anything.
Absolutely.
To have the policy audited. But the delegation of investment responsibility is really a huge concept over the last several years. I'll just preface it by saying a trustee can never fully delegate a fiduciary duty to a non-trustee. There are ways to bring in a co-trustee, investment trustee, let's call him or her, and then the one trustee can delegate the duty with regard to investments to the other trustee.
Right.
That is one structure where you have maybe a sort of a family distributions trustee in charge of who gets what and when, and then you may have an investments trustee. There's a concept, but I think that the more common concept is where a single trustee, perhaps an individual, not a corporate trustee, would seek out an investment advisor and then delegate the investment function to that person. So while the trustee is not delegating the fiduciary duty per se, as long as the trustee does his or her due diligence and reasonably selects a competent investment advisor, it's kind of a couple terms of art in there, but it's just like it sounds. If you spend some time on it, pick a good advisor, and then delegate the investment function to that advisor, the trustee really has a lot of cover in that scenario. So the variations or fluctuations in the market, the trustee's not going to be held to account for that. Now, the investment advisor needs to continue to act reasonably and competent, so the trustee has a continuing duty to make sure the investment advisor, is still a good investment advisor, but is no longer the guarantor of investment performance, which is the big point here. So
It would also seem it would be prudent for the trustee who's doing the delegating to document that due diligence process.
Oh, absolutely.
So that they have proof of what they did to arrive at that conclusion.
Very much so. Keeping a file with all the various disclosure documents and documenting the interview process.
Makes sense.
So.
That makes sense. Well, I think that that wraps up the areas that we wanted to cover today on the webinar, and I'd like to thank Bob for being here with us today.
Very interesting. The opportunity, Brad. Appreciate it.
No problem at all. If you want to connect with Bob regarding a personal situation or to talk to him about doing some planning for your own family, you can, two ways to do that. You can either reach out to Bob directly. We provided his biography and we of course have his contact information here at the office at Capital Rock Investments, or we can set up a joint meeting with us, with your permission, to meet with Bob however you feel comfortable about doing it. Either way is fine with us. You don't have to contact us at Capital Rock at all. You can go directly to Bob, and Bob's got a fantastic website out there. I should also mention that Bob and I happen to be next door neighbors, so I have pretty good access to Bob, and if he for some reason doesn't do a good job for somebody, which would never be the case, he's very close by for me to stalk him and do all kinds of strange things to his house. Yes. So our second session in this series on trusts and estates is going to be entitled Ways to Lighten the Trustee Burden, and we're going to hold that webinar same time at noon on Tuesday, February 3rd, and we'll be sending out another email invitation for everybody to register. That session will also include a guest visit from Capital Rock Portfolio Manager Philip Morrissey, who is located over in our Aventura, Miami office. And Phil is a former trust portfolio manager at SunTrust and Bank of America. So we'll have Phil and Bob with us for that session. And then the third in this series, which we have planned for Tuesday, February 17th, same time at noon, will be entitled Delegation, Not Dereliction of Duties. And again, email invitations will be sent for those shortly. I don't see any current questions in the queue. So with that, I think we will conclude this